Okay, ma? Shall we start? What was our earlier discussion? Appointment, reappointment, rotation. Huh? Bidding. Didn't complete it? Director identification number. How many digits? 8. Okay. Next one. So, in case of appointment, first directors, subsequent directors, discussion completed. Rotation, 2/3, 1/3, rounding off provisions. Rounding off provisions. There is a complicated point lies within rounding off section. How many of you know that point? How will you round off? In case of 2/3, how will you round off? You must always consider next number. In case of 2/3 rounding off, it means 5.2 means 5.1 means 5.1 also 6. Huh? That is the meaning of considering next number. In case of rotational directors, 2/3 we will consider. In case of retirement, we will consider 1/3. Na? In case of calculation of 1/3 provision, if fraction appears, then we will round off to nearest number. She zoned out of the class. No? Okay. Yesterday, have you completed the listening of recording the class? No? That's why you zoned out of the class. Okay. So 1/3 fraction is, we will round off to nearest number. It means 4.2 means 4.2 means 4. In the previous example, you said 5.1 means 6. Now you are saying 4.2 means 4.2 means 4. 4.7. So that is the discussion we have completed with respect to rotation. This is also completed in case of okay. In case of calculation of rotational directors, what kind of directors we must include in the total strength and what kind of directors we must exclude from calculation of total strength. From total strength of directors, independent directors, nominee directors, small shareholder director, additional director, these are all included or excluded? Excluded. From the remaining figure, we have to do the calculations. Okay, 2/3 and 1/3. Here it is, 2/3. Rounding off to next number. 1/3, round off to nearest number. Next one, retiring process. This is also we completed, if I am not wrong. Retirement will be done by mutual consent. If there is no mutual consent, if two directors are appointed on the same day, then the tenure will be the same, right? Then next, resignation also we completed. Resignation also we completed? No? Okay. Resignation and removal. So this is a bunch actually. We will complete today. And along with resignation and removal, we will also try to complete POI. At the time of appointment of a person as director, he must submit 3 documents. What are those 3 documents? He must submit DIN. It is a mandatory thing. And he must submit POI, particulars of interest in other entities. Third point, consent number is DIR 2. Very good. So these are the mandatory documents. So today we will try to complete the discussion with respect to POI also, particulars of interest. That is section 184. 184. And after the completion of resignation, removal, POI, if time permits, we will discuss powers and duties. After completion of discussion, we will close this session. So after this session, the leftover topics will be KMP, key managerial persons, KMP, remuneration of directors, and section 185, loans to directors. If we complete these 3 topics, directors and KMP will 100% completed. Okay, let's quickly revise. Let's quickly discuss the process of resignation. Okay, so resignation is a voluntary thing, or I think you all know about the difference between resignation and expulsion. What is meant by resignation and what is meant by expulsion? Expulsion means forceful removal. Expulsion means forceful removal. So you are being removed by members, or you are being removed by board of directors also in some cases. So resignation is a voluntary thing or a forceful thing? Voluntary thing. Okay, in case of resignation process, you have to remember only one form from director's point of view. That form number is DIR 11. DIR 11. And from company point of view, yesterday what we have discussed, DIR 12. DIR 12 talks about changes in the directorship of a company, directors of the company, whatever the change it may be, death, disqualification, appointment, reappointment, whatever it may be, you have to intimate to MCA through DIR 12 within a period of 60 days, right? Within a period of 60 days, 30 days. Okay, so actually the discussion has been completed. So resignation of director. First thing, a director can resign at any time by simply serving a notice to board of directors or company secretary, if any. If there is company secretary in the company, he can submit his resignation to CS also. There is a possibility. There is no hard and fast rule that you must submit your resignation to BOD only. If BOD is not available, to whom you can submit your resignation? To CS also you can submit your resignation. If there is no company secretary in the company, you have to submit to board of directors. Simple. Okay, so obligations from retiring director point of view. Retiring director means nothing but the director who is going out of the company by simply serving a resignation notice. From his point of view, the obligations are two. First thing is, in case of public company, in case of which company? Listen carefully. If a director is resigning from a company, let's check whether it is a public company or it is a private company. If it is a public company, there is an obligation from the part of retiring director that he has to submit DIR 11 to MCA. He has to submit DIR 11 to MCA. DIR 11 consists of why you are going out of the company. What are the reasons for your resignation? Why you are going out of the company? Whether it is because of your personal reasons or your professional reasons, whatever the reasons, you have to mention, you have to inform to MCA. DIR 11. Okay, and one more obligation is also there. Just because you have submitted your resignation, you are not cleared from your existing obligations, or you won't get any sort of freedom from the decisions which have already taken. During the course of your tenure, you have taken some decisions, right? You are collectively responsible for the decisions. Say for example, you have been appointed as a director into the company from 1st January 2023. Today's date is 9th or 8th? 9th July 2025. So from 2023 January 1 to till this day, you might have participated in multiple board of directors meetings, and collectively you might have taken number of decisions, right? You are collectively responsible for all the decisions which you have already taken in the meetings. You won't get any sort of freedom from the existing decisions. You will get freedom from today onwards. Say for example, tomorrow they conducted a board meeting and they taken a decision. For that decision, are you going to be responsible for that decision? No. Why? Because you have already taken exit from the company. This is the point. Okay. So these are the 2 points. Obligation point of view. These are the 2 points. Direct resignation, the retiring director or director who is going out of the company will not get any sort of freedom from the decisions which they have already taken in the previous board meetings. Clear? So first obligation is DIR 11. Second obligation is they are still responsible. They are still accountable for the decisions for which they have already taken in the previous board meetings. They won't get any sort of freedom. Are we clear with these 2 points? If it is a private company, no need to submit DIR 11 to MCA. MCA Companies Act rules have been clearly exempted private companies from the requirement of filing DIR 11. But listen carefully. If private companies' articles of association adopted the rule, that means if private companies' articles of association is clearly saying that whoever the director is going out of the company by simply serving a resignation to us, they have to submit DIR 11, then these provisions will still attract to private companies also. That means in first case, Companies Act rules has been given relaxation for you. But whether you are going to enjoy that relaxation or not depends upon your AOA. What is AOA? Articles of Association. If your Articles of Association is silent and doesn't speaking anything regarding DIR 11, no need to file DIR 11. Why? Because you are you submitted resignation from a private company. Then no need to submit DIR 11. When you are going to submit DIR 11, if your private company's AOA is clearly saying that you have the obligation to file DIR 11, then only you are supposed to file DIR 11. Otherwise, no. Clear? Public company, private company cases clear. And the second point is same thing, same applicable to public company as well as private company. Whatever the decisions they have taken during the course of their tenure, for that decisions they are collectively responsible for those decisions. At any future point of time, if any investigation, if any what we call SIT has been formed, they have each and every right to call the director with respect to inquiry about the decisions. Okay. This is all about resignation. So first of all, obligation. Just a minute. First of all, obligation. Obligation from retiring director point of view. First point, what is this? Must. What is meant by must? Must file DIR 11 within. Relaxation is available to private companies, but in order to use that relaxation, AOA must specify accordingly. If your AOA articles of association is clearly saying that you have the obligation to file DIR 11, forget about exemption notification. You have to submit DIR 11 within 13 days. What you are going to say in DIR 11 to MCA? Why you are going out? Why you are taking exit from the company? What might be the reasons for your exit? You have to upload supporting documents and you have to inform to MCA with respect to your resignation. That's it, nothing other than that. Next one, RD, retiring director still responsible for the past decisions or actions taken during his tenure. These are the obligations from director point of view. Director point of view. Remaining, company point of view. I hope you all are well versed with DIR 12. Why? Because we have already discussed with respect to DIR 12 concept yesterday only. As and when there is a change appears in the directors, then you have to intimate to MCA within 13 days through the form DIR 11. Here also it is must or may. Must or may. Company must file DIR 12 within 30 days and must disclose in board report. Next one. Effective date of resignation. What is the effective date of resignation? Say for example, today I have given resignation. In that resignation letter, I have clearly stating that from 12th July onwards, I am taking exit from the company. I am going to resign. I am going to vacate my office from 12th July. I have to say always a present date or a future date. I can't say a past date. What is this month? July. Can I quote June month? Can I quote May, April, February? No, I should not quote like that. I should always quote a present date or a future date. Say for example, if I mentioned any date in my resignation letter, you please follow accordingly. From that date onwards, my responsibilities will be discharged. I have no relation with the company. If I stated nothing, I didn't mention any sort of date in my resignation letter, then the date of serving the notice will be considered as resignation date. That is the concept. First of all, effective date of resignation. First of all, date mentioned in the notice. First of all, let's check whether is there any date mentioned in the resignation letter. Yes, sir, mentioned. Follow accordingly. Sir, no date has been mentioned in the resignation letter. Then date of serving the notice to the company, whichever is later. Whichever is later. Say for example, today I am giving notice to the company, saying that from 14th July onwards, I am going to resign from my directorship. So what is the effective date of resignation? 14th July. Why? Because I have clearly mentioned a date. I didn't mention anything. I simply served a notice tomorrow morning. Then what is the effective resignation date? From tomorrow onwards, I am going to discharge from my responsibilities. From tomorrow onwards. Till yesterday, I am going to responsible for all the actions taken during my tenure. Okay. Note, in case of OPC, how many directors will be there in OPC? Only one director. Then how come one director will resign? That is why if you wish to take a resignation from OPC, then you have to, first of all, you have to appoint another person as director in your place. Then after, you can take exit from the company. You can't simply take exit without appointing anybody in the place of your directorship. You have to appoint someone. Then only you have to take exit from OPC. Clear? That is why the point is mentioned like this. In case of OPC, sole director. Sole means multiple or single? If there is single director, sole director can resign only after appointing another individual as a director. Of course, you all might know only individuals are allowed to act as directors, right? Body corporates allowed? Only individuals are allowed. Okay. This is all about resignation or removal. Actually, tomorrow yesterday I forgot to make discussion with respect to this table. This is a summarized table where which director is appointed by whom. What is the appointing authority of the director? Now I am going to discuss. Before that, let's quickly discuss the resignation part. This is the resignation part. Section 168. So manner of resignation. Director must submit a written notice of resignation to the company. And let's check out whether is there any new points apart from our discussion. Resignation date, effective date I have already discussed. Obligations I have already discussed. Obligation DR 11 I have already discussed. Liabilities post resignation, OPC. Everything is covered. No point has been left over. Okay, let's quickly discuss about this table. Summary about appointment of BOD. So who has the appointing authority to appoint? Several types of directors are there, right? So let's quickly discuss. First of all, additional director will be appointed by who has the appointing authority to appoint additional director? Board of director. Actually, the power to appoint additional director also lies with members only. Genuinely speaking, the power to appoint additional director lies with members. In general, 95% of cases, members will delegate the power to appoint additional director to board of directors. You please take care of the appointment of additional director. We don't want to involve. Why? Why? Because I have already discussed in yesterday's session. What is the relevance with respect to additional director when we are going to appoint additional director in our company? Say for example, if an experienced fellow is there, we wish to utilize the services from that experienced fellow. If we offer employment to that person, what he will do? He will simply reject. That is why we will offer directorship to that person. Directorship will not come under employment. Then he will happily join with our company, and we can also happily use his or her expertise. So when we might incur the need of additional director, we also don't know. With respect to our business decisions, the need might arise or might not arise. That is why the power to appoint additional director will be delegated by members to board of directors. The original appointing authority is members only, but in general, 95+% of the cases, the appointment of additional director will be done by board of directors. Why? Because appointing additional director is a regular course of business. If need occurs, we will appoint. If there is no need, we will not appoint. That is why, with respect to on needy basis, directors will take the decision. That is why the power will be delegated from from members to board of directors. That is why additional director appointing authority is whom? Board of directors. And the second one, you all know casual vacancy director. What kind of vacancy will be called as casual vacancy? First of all, let me know what kind of vacancy will be called as casual vacancy. I have already clearly discussed with respect to this casual vacancy. Resignation and all okay, but every vacancy will not be termed as casual vacancy. What kind of vacancy? Excellent. Speak out loud. Director appointed by shareholder. Director appointed by shareholders. If a director has been appointed by shareholders, and that director is going to vacate the office even before the expiry of his tenure or time, that kind of vacancy will be called as casual vacancy. The reason might be anything. It might be resignation, or it might be death, disqualification, whatever the reason it may be. So this kind of vacancy will be called as casual vacancy. Listen carefully. We appointed additional director. For a period of 1 year. After completion of 3 months, that additional director resigned from our company. Now, the vacancy created in the place of additional director will be called as casual vacancy. Casual vacancy? No. That is the important thing. Why? Because additional director appointed by whom? Board of directors, but not by members, shareholders. That is why vacancy in the place of additional director will not be termed as casual vacancy. Clear? So in case of casual vacancy, who will fill up the position? Originally, who needs to fill up the position? Originally, members need to fill up the position, but the power will be delegated to board of directors. Why? Because in order to just fill a casual vacancy, if you wish to convene a general meeting, it is a expensive affair. That is why, from cost point of view and from administration point of view also, it is not viable to convene a general meeting just to appoint a casual vacancy, just to fill up a casual vacancy position. Okay, that is why the power will be delegated to, the authority will be delegated to board of directors. So are we clear with these 2 points? So why the appointing authority is board of directors, clear? Third point, nominee director. It is also done by board of directors. Why? Because nominee director will be nominated by financial institutions or insurance companies or banking companies or sometimes central government or state governments in order to represent their interests, represent their membership. They will nominate some other persons. Those persons will be called as nominee directors. Next one, alternate director. This is also, these positions are also appointed by board of directors only. First directors, I have already discussed this first directors concept in yesterday's session. You have to check AOA. You have to check AOA with respect to who are the first directors. If AOA mentioned about this person is a first director, this person is a first director. If AOA mentioned regarding with respect to the names of first directors, happy. If AOA is silent, subscribers, we should not term like that. Individual subscribers. Why? Because subscribers may be body corporate also, na? So that is why all individual subscribers who are subscribing to MOA will become first directors. And regular or ordinary directors, this is an important thing. In general, regular directors or in general, directors will be appointed by whom? Members. In which meeting? General meeting. It may be AGM or EGM. That is why we have already discussed 4 points. Ordinary business 4 points. Who is going to tell 4 points? Who is going to tell? Who is going to tell me that 4 points? Ordinary business 4 points. 4 points. These 4 points will be called as ordinary business or regular business. Apart from the 4 points, if any other business is there, it will be called as extraordinary business. Anybody know about those 4 points? Tell me. Super. Adoption of financial statements, appointment of auditors, appointments of directors, declaration of dividend. These are the 4 points. I have already discussed it earlier. Sit down. Next one, independent director. At first place, the appointment of independent director will be done by board of directors. After that, the appointment will be ratified by members in next general meeting or next coming 3 months. Next one, MD, WTD, executive directors. These are all appointed by shareholders only. Next one. So with respect to, this table is very important with respect to appointing authority. In future, everybody is writing what they are writing. Listen carefully first of all. In future, if you guys face any sort of difficulty regarding who is going to appointed by whom, who has the appointing authority with respect to appointment of such director, then simply refer this table. You will get crystal clear clarity. Okay, next one. So appointment, reappointment, rotation completed, appointing authority completed, resignation removal. Yes, resignation completed. Just now we completed resignation. What are the forms applicable for resignation? DIR 11 and 12. DIR 11 filed by company. DIR 11 filed by retiring director. Director who is going on resignation. In how many days? DIR 11 mandatory for which company? Public company. Private companies it is not mandatory. But if AOA mentions so, then you have to file DIR 11. DIR 12 mandatory. 100% mandatory. From which point of view? Company point of view. How many days? Next one. Removal. This is also a simple at the same point of time important thing. Listen carefully. Removal of directors. Removal of directors. Difficult questions answers lies with simple analysis. If we peacefully analyze the situations, we can find solutions for 95% of questions. So before we will discuss about the concept of removal of directors, we have already discussed the appointment process, right? In general, who has the appointing authority to appoint directors to the company? Members. Who has the appointing authority? Members. By which resolution they are appointing? Ordinary resolution. Special resolution not required, ma. Just ordinary resolution is enough. Okay. So, if members got the power to appoint a person into the position of a director by passing an ordinary resolution, then why can't members don't have power to remove the director by simply passing an ordinary resolution? Possible, right? This is the whole concept. So, in order to remove a director, just ordinary resolution is enough for members to remove a person from a position of directorship. It is as simple as that. It is as simple as the appointment process. Members are simply appointing a person as director by passing a ordinary resolution in the meeting. Which meeting? It may be any meeting, any general meeting, AGM or EGM. In the same way, members will got the power to remove any person from the position of directorship by simply passing a ordinary resolution. So, for appointment or removal, which resolution is required? Simply ordinary resolution is required. End of the day, who are the owners of the company? Directors are the owners. Members, shareholders are the owners. To whom the company belongs? Shareholders. That is why ownership belongs to shareholders. That is why they have each and every decision to appoint you or remove you. It is as simple as that. Clear? But there is a administratively, from administration point of view, there is a simple concept or a simple rule. We have to follow this. What that rule says is, in order to remove a director, you have to follow some criteria. What is that criteria? Just a minute. 161. There is a simple criteria. Listen carefully. The proposal must be done by, if you wish to remove a director, you can remove, but the proposal must be done by the persons who are holding at least 5 lakh paid up share capital, at least 5 lakh paid up share capital, or 1% voting power. They should give a notice to the company. They should give notice to the company not less than 14 days from the date of meeting. 14 days from the date of meeting. In other words, we can also say like this. So, what is the minimum time gap between date of serving the notice with respect to calling the meeting and the date of holding the meeting? 21 clear days. How many days gap is mandatory, ma? How many days gap mandatory? 21 clear days, right? 21 clear days. From the date of receiving the notice, you have 7 days time. After consuming 7 days from 21 days, how many days are left with? You left with 14 days. That is why rule mentioned like this. So, you have to inform to the company, or you have to serve the notice to the company at least 14 days before the date of the meeting. Then what company needs to do from the day, at least 7 days before the meeting, company has to inform about this agenda to other members as well as the so-called removal director. The director which the members intended to remove is there, na? So, company needs to intimate to the director. Mr. X, the proposal has been received by us for your removal. Is there any representation you wish to make to the members? If you wish to make any representation, type it and give to us. We will circulate it to the members along with the notice. If time not permits for the circulation, if time not permits, then director has the power to read out the representation in the general meeting itself. In the general that is what we call an opportunity of being heard. Opportunity of being heard. Few minutes back we have discussed with respect to ordinary business and extraordinary business. What are the 4 points? Adoption of financial statements, declaration of dividend, appointment, reappointment of auditor, appointment, reappointment of directors, right? Removal of director is mentioned, included in that 4 points. No, right? So, removal of director will be a 5th point. That is ordinary business or extraordinary business? Extraordinary business. Clear? So, this is the point. So, it is quite possible for the members to remove any director from the company. But before doing so, they have to follow 14 days notice policy. They have to intimate to the company at least 14 days before the date of meeting, saying that we wish to remove, we intended to remove that person as director. Then company will inform other members as well as removal director with respect to his removal. So members are intended to remove you. If you have anything to say, give us representation. We will circulate your representation to members as well as they will circulate in the newspaper also, vernacular local language newspaper as well as English newspaper, time not permits. And if anything required to, if director intends to say something, then he should be served with the opportunity of being heard in the general meeting also. Without listening the point of view of directors, you can't remove the director. Okay, so this is all about removal of director. Removal of director. Just a minute. Yes. Part 2. Section 169, removal of director. So first of all, what is the question is saying? Who can remove the director? Who can remove the director? First of all, a company may remove a director before the expiry of his term by passing special resolution. Simply ordinary resolution is enough. By which power they have appointed? Ordinary resolution. By which power they can remove you? In general meeting. However, following directors cannot be removed under this section. These are the 2 points. First of all, directors appointed by the tribunal. If a director is appointed by a court or tribunal, there must be a purpose, right? Then how can you remove that person? That is why, who has the appointing authority? Tribunal, right? Who can remove it? Tribunal. And next one, director appointed under proportional representation. We are going to discuss about proportional representation in oppression and mismanagement. As of now, not required. Oppression and mismanagement. In simple, we can say that proportional representation, this method will be, this is an optional method, not a mandatory method. In the course of appointment of directors, companies might follow proportional representation method. This method has the policy to facilitate the minority investors to make their representatives into the board, to put the representatives of the minority investors into the board. This is a extensive process which I am going to tell in prevention of oppression and mismanagement. I think it is the chapter number 10 or 11, last but one chapter it is there. There are 3 chapters: inspection, inquiry, investigation, compromise, arrangement, amalgamation, and oppression and mismanagement. At oppression and mismanagement, we are going to discuss about proportional representation. As of now, not required. As of now, simply remember in mind that 2 directors cannot be removed by members. 1 director appointed by tribunal or court. Second one, directors appointed by proportional representation. Proportional representation. US president elections will also be done in the same manner. Preferential voting method also. Have you ever listened about this? Have you ever heard about this preferential voting method? First preference vote, second preference vote, third preference vote. Proportional representation, we can follow that method. I'll clearly discuss. No worry. As of now, not required. No, no, no. Nominee director and this one entirely different. Hmm? No, no, no. Nominee from removal point of view, you're asking. No, no. Nominee director also, members can't remove nominee director. Why? Because he has been appointed on a purpose. Who has the appointing authority? Board of directors. After consideration of proposals from financial institutes or bank, government, etc., etc., who will appoint? Board of directors. Who can remove? Simple. Next one. Huh? Yes. Yes. After consultation only they will remove. Members can't remove. That is what I am saying. His question is, that is what your question, right? Is our members are allowed to remove nominee director? The answer is big no. Clear? Whatever the changes in nominee director they have to do after consultation with the that nominated person as well as board of directors. Okay. After consultation only they have to do the changes. Members can't do changes on their own. Okay. Next one, special notice. First of all, how many percentage of total voting power? At least 1% voting power, or paid up share capital how much? 5 lakhs. Must give special notice to the company at least 4 days before 14 days before the meeting. Notice to directors. Company must immediately send a copy of the notice to the concerned director. Dear director, members are going to we received the proposal from members with respect to your removal in the upcoming meeting. Be prepared accordingly. If you wish to make any kind of representation, give it to us. We are going to circulate in the circulate along with the notice, additional notice. Okay. If time not permits, you can make that representation in general meeting itself. Next one, right to be heard. This is what the point. The concerned director has a right to make written representation and request circulation to members. If not circulated, why it is not circulated? Due to lack of time. If time does not permit for the circulation, then the director may request for the representation to be read in the upcoming meeting, general meeting. The company must call a general meeting, either AGM or EGM, and pass ordinary resolution to remove the director. And this is all same. DIR 12. Why we need to file DIR 12? Removal of director amounts to change in directors, right? That is why we have to follow DIR 12. Within how many days? Director's rights during removal. What are the rights available for the director and the process of removal? First of all, right to receive a copy of the special notice. Why it is called as special notice? Again, what I have told earlier, what is the ordinary business? What are the points to be considered as ordinary business? That 4 points, na? Any point other than these 4 points will be called as special business, right? Special agenda, special business. That is why right to receive a copy of the special notice. Director has the right to receive the copy of special notice. Who is going to serve the special notice to the company? Shareholders. How many shareholders? Shareholders collectively must hold at least 1% of the voting power, or cumulatively hold at least 5 lakhs paid up share capital. Next one, right to make written representation. Generally, directors will used to get emotional in that written representation. I have invested my blood and sweat in the growth of this company. How can you remove? So you are going to suffer. You can't find some Insta quotes. Some Insta quotes also they will add. You can replace me, but you can't find a vibe like me. What kind of quotes they used to add? Next one, right to attend the meeting and be heard. Right to attend. He has the right to attend the meeting and has the right to be heard. Next one, comparison table with respect to resignation as well as removal. First point, who initiates resignation? Who initiates? Director itself initiates resignation. But who initiates removal? Shareholders. Next one, governing section 168, 169. Not that much important. Next one, need for board resolution. In case of resignation, board resolution is required. No. Here, in case of removal, board resolution is required, but not with respect to removal, but with respect to convene general meeting. Where the resolution will be, ordinary resolution is required to remove the director, right? Where the resolution will be passed, general meeting, right? In order to convene a general meeting, board of directors has to convene a meeting, has to pass a resolution, right? That is why board resolution is required. Next one, filing with ROC, DIR 12, DIR 12, mandatory. Next one, in case of resignation, DIR 11, from director point of view, optional word has been used. Why it has been used optional? For public companies, DIR 11 filing mandatory from director's point of view. If you are going to retire from a public company, DIR 11 filing is mandatory. But if you are retiring from a private company, is DIR 11 mandatory? No, optional. When it is mandatory? If your private company's AOA adopted that point, then it is mandatory. Otherwise, it is completely optional. But what is the good practice and what is the best practice is, whether it is a public company or whether it is a private company, filing DIR 11 is practically highly suggested. Why? Because, say for example, you are retiring from a private company. You are retiring from a private company. And you have already studied about all the rules and regulations, and you came to know that DIR 11 is optional for me. Why should I file DIR 11? Jane do. You relaxed. Company also forgot to file DIR 12. Or company intentionally didn't file DIR 12. As per records, you are officially as director, right? If company commits any mistake, who is responsible? You are also collectively responsible. So in order to avoid these kind of confusions in practical environment, it is highly suggestible for each and every director to file DIR after their resignation. Next one, right to be heard. Here it is not applicable. Why? Because the director itself is taking the decision with respect to resignation. Then why again right to be heard is required? In case of removal, yes, the right to be heard has to be given by the company to the director, and it is a mandatory thing. Liabilities post event, continues for acts done during the tenure. Here also continues for acts done during the tenure. Liability will continue. Mandatory in OPC, must appoint a replacement before the resigning. I have already told this point now. Sole director has to appoint another person in his place before the resignation. He can't just like go out of the company. Next, not practically applicable. Why not practically applicable? How many members there in OPC? One member. That one member has to convene a meeting and remove the director. No, that is why removal of directors in OPC not practically possible. Next one, remuneration. Remuneration is a big topic which I am going to dedicate the tomorrow's session for discussion of remuneration, as well as anything leftover topics like 185 loans to directors, etc. Now, let's quickly discuss 184 POI. 184. Listen carefully. First of all, listen carefully. Don't see the materials. First of all, listen carefully. (184) POI in other entities. Particulars of interest in other entities. As per section 184, a director must submit particulars of interest in other entities in 3 times, or 3 cases, or 3 circumstances. What are those 3 circumstances means? First of all, first board of directors meeting after his appointment. Generally, at the time of appointment only, the mandated documents we have already discussed in 3 documents. One is DIN, second one is POI, third one is consent letter. Along with consent letter, he usually furnish a POI. If he forgot to furnish POI at the time of appointment, at first meeting there is no exemption. Now you don't know extension of time. At first meeting, you have to submit this document. This is the first case. This is the first case. And the second case, if there are any changes in the particulars, say for example, I am a director. At the time of appointment, I am holding 7% shares in ACC Limited. Cement company is there, na? ACC Limited. In ACC Limited, I am holding 7% shares. I have already disclosed that matter at the time of appointment. After appointment, I have increased my stake from 7% to 9%. That means recently I bought some more shares in ACC Limited. So there is a change in my ownership, right? So now also I have to intimate the company with respect to change in my ownership. If there any change in the particulars of the interest, then also I have to intimate the company. And third point, annual basis. Annual basis means each year. Every year you have to update the particulars of interest with respect to your holdings with other entities. Why company is insisting you to file these particulars of interest in other entities? In order to decide whether you are an interested director or not. Why? Because Companies Act prohibits participation of interested directors in the meetings with respect to decision. Say for example, X Limited. In X Limited, Mr. A is one of the director. X Limited is going to form a joint venture, or X Limited is going to enter into a contract with Y Limited. In Y Limited, A is holding 6% ownership. 6% ownership. There is no disqualification. This is not a crime to hold shares in other company. Not a crime. No disqualification, nothing. The only requirement is, so now if in other companies, no one is prohibiting you to hold shares in other company, you can peacefully hold n number of shares. Not even 6%, you can hold 66% also. The only requirement is you must stay away from the decisions in which a board meeting has been held with respect to continuance of contract or extension of contract or entering into new agreement. What kind of decisions? Say for example, now X Limited and Y Limited are going to form a JV. What is JV? Joint venture. Now in today's board meeting, X Limited's management and Y Limited's management is going to take a decision with respect to formation of that JV. You get out of that board meeting. You stay away from it. Go to some stall and eat punugulu bajjil. Don't participate in the meeting. If you participate in the meeting, that is what we call the 184 particulars of interest deviation, section 184 deviation. Then you will incur penalty as well as imprisonment. That is the only requirement. So holding shares in other company is not a prohibition or a disqualification, nothing. The only requirement is, in order to decide whether you are an interested party or not. For that purpose, we are asking the particulars. Point number 1. If you are an interested party, you must stay away from the board meetings in which the decisions will be taken with respect to the decisions or contracts. Sir, when I will become interested party? If you hold 2% or more on the ownership of the other company or other entity. At least which percentage? 2%. Say for example, I am holding 100 shares in Tata Motors. 100 shares in Tata Motors. 100 shares, for example, I think around 10 crore or 50 crore shares there are there in Tata Motors. How many shares I am holding? 100 shares. Will it amounts to 2% or more? Not even 0.0%. So that is why now I will be called as an interested director. I should stay away from that meeting. No, I can participate in the meeting. If our company is holding a JV with Tata Motors, or if a company is entering into a contract with Tata Motors, I can happily participate. Why? Because I am not an interested party. Just because I am holding 10 shares, 100 shares, 40 shares, not a bar or not a prohibition. You can hold. But what is the only requirement is, if you will become an interested party, you should stay away. Sir, I am holding shares, but I am not becoming an interested party. You can happily participate in the meeting. No prohibition. Okay. So, just a minute. Yes. This is the point. So, 184. What 184 is saying? Disclosure of interest by directors. So, let's quickly read out these three cases. First one, disclose his interest in any company, body, corporate, partnership, firm, association of individuals, including shareholding. And the disclosure must be made in three cases. First case, at the first board meeting in which he participates as a director. That is why I stated that at the time of appointment, you have to submit 3 documents along with DIN, consent letter, POI also you have to submit. That is the first point. Clear with first point? Second point, at the first board meeting of every financial year, annual basis. Annual basis I have clearly told, na? But every financial year you have to update. And whenever there is change in disclosures, your ownership has been increased from 6% to 7% or decreased from 6 to 5. Is there any change in particulars? Intimate to the company. Disclosure should be made in form MBP1. Not an important point. From practical point of view, I have included that point. Not a big deal. Next one, 184.2, specific disclosure in transaction. Read out carefully. If a director is directly or indirectly interested in a contract or arrangement. Sir, when a person can be termed as directly interested or indirectly interested, in this case, a body corporate where he holds greater than or equal to 2% shareholding or ownership, or is a promoter, or he is a manager, or he is a director, or a firm in which he is a partner, owner, member. In these two cases, what you have to do? You must disclose nature of interest at the board meeting and not participate in the meeting where that contract is discussed. The connecting point is and or and. That means you have to disclose your interest. That is obligation number 1. And obligation number 2, you get out of the board meeting. You must not participate in that board meeting. Why? Because conflict of interest will there, na? That is why you must not participate in the decision taking meeting. Non-compliance, if you don't follow, offense will be contravention of section 184, penalty will be 1 lakh, and the contract is voidable at the option of the company. At this point of time, at final level, I should not talk about void, voidable, valid. I think you all are aware about what is meant by voidable contract. What is meant by voidable contract? Voidable at the option of one or more, but not at the option of other or others. Voidable at the option of simply aggrieved party. Say for example, I am holding 4% ownership in the other company, but I intentionally disclose it that I am holding just 1% or 1.5%, and I have participated in the meeting. No one knows that I am holding 4%. Why? Because I disclosed only 1%. After entering into the contract after 1 month, they observed the shareholding pattern, and the company directors came to know that I am holding actually 4%, but not 1%. Then the contract can be voidable at the option of company. They'll simply state that they are aggrieved parties, I am the defaulting party, and they blame me and cancel the whole contract. There is a possibility also. So in order to avoid all these mess, what I should do? I should stay away from the meeting. That is the simple thing which I can do. This is all about section 184. 184. Tomorrow we'll discuss about 185, loans to directors, as well as 188, holding of office or place of profit. These are two simple topics. 5 minutes, 5 minutes. Loans to directors 5 minutes, and 188 also 5 minutes. After that, powers and duties of directors as well as remuneration. Of all the remaining topics, which is what is the important or the time taking concept is remuneration. That is the important concept. Remuneration. So we will be left. Now we are lefting in directors and KMP. Oh, KMP is also there, na? KMP we will discuss. Just a minute. KMP. Are we done with the discussion with respect to difference between MD, manager, whole-time director? In types of director. No. I'm not talking about. Just a minute. Give me 1 minute. Duties, delegable powers, non-delegable powers, powers and duties. Yes. Difference between MD, WTD and manager. Actually, I have already discussed I have already completed individual discussion. Who is an MD, who is a WTD, who is a manager. That thing we have completed. But if we discuss, if we complete the discussion with respect to this table, the complete picture will be clear for you with respect to who is an MD, who is a WTD, who is a manager. Listen carefully. I have 2 minutes, 2 more minutes, 8:13. 2 more minutes are there. Listen carefully. MD, WTD, manager. Listen carefully. Among MD, WTD, manager, who has the substantial powers means MD. And listen carefully. MD and manager simultaneously can't exist in a same company. I have already told this point to you in the earlier sessions. Only one person is allowed. Having multiple managing directors allowed in a single company? No. If you wish to have multiple person, you can have them by the name of joint MD. But can't have MD1, MD2. Not like that. That is why MD and manager simultaneously can't exist in a single company. Actually, CEO is the word we derived from Western community. Companies Act don't know the word called CEO. In general, in the place of MD or in the place of manager, we will use CEO, Chief Executive Officer. Okay, so listen carefully. First of all, managing director must be a director, yes. WTD also director, but manager not necessarily be a director. Why? Because manager may be an employee also. Manager may be an employee, not necessarily becoming a director, not necessarily be a director. This is the difference number 1. And difference number 2, employment terms. MD may be a full-time employee or may not be a full-time employee, but WTD must be in full-time employment with our company. Must be. Whole-time director, full-time he must be in our employmentship. Next one, manager also same, full-time employee. Third difference, substantial powers. WTD does not have substantial powers. WTD will have segmental powers with respect to some divisions only. Operational director, material department, finance department, HR department. In that way, only with respect to some segment only, he will be having powers, not substantial powers over the company. But substantial powers are having with manager or MD. Sir, Simultaneously, manager and MD have substantial powers. How it is possible? That is why I am saying a company can't have manager and MD at the same point of time. Either you will have MD or you will have manager. That's it. Simultaneously, you can't have multiple persons. Next one, subordinate to the board. Yes, everybody is the subordinate to the board. Why? Because board includes executive directors, non-executive directors. I think you all know difference between executive and non-executive. Executive means have to participate in the meeting. Non-executive participate in the affairs of the company. Non-executive occasionally participate in the affairs and they will participate in policy making decisions. Will not participate actively engage in the day-to-day affairs of the company. So board is greater than who is having more powers, board or manager? Board. In simple, we can conclude this discussion. Who are the actual owners of the company? Members. But members can't actively participate in the day-to-day affairs. That is why as an agents or trustees, they appointed BOD. In that BOD also, executive class is there, non-executive class is there. Non-executive can't participate actively engage in the day-to-day affairs of the company. That is why they have made another trustees or another agents. Those people are called as MD, WTD, manager, like that. Clear? So BOD always have superior powers or superiority over MD or over WTD or over manager. So who got more powers than manager or WTD or MD? Who got more powers? BOD. Why? Because BOD means all directors, executive, non-executive. Next one, governing section. This is not a big thing. 254, 253, 294. Okay. So this is our discussion. So we left with KMP, 10 minutes discussion, 185, 5 minutes discussion, 188, 5 minutes discussion. Powers and duties of the board. This is around 15 to 20 minutes discussion. Around 1 hour it will take, and over and above remuneration is there. That is the most important thing than all these 4 topics. I think around 40 to 45 minutes I should require with respect to remuneration discussion. And we can expect a practical question at final level with respect to remuneration. Why? Because there are sublimits. Percentages are there. 11%, 5%, 10%, 1%, 3%. And what if there is a profit and what if there is no profit? If company has no profit, they have to give remuneration on effective capital basis. What is meant by effective capital? These are all things we have to discuss. That is why 40 to 45 minutes we require. Okay, let's discuss tomorrow. Thank you. I hope by tomorrow or day after tomorrow. Tomorrow which day? Today is Tuesday or Wednesday? Wednesday. Tomorrow, Thursday, Friday. By Friday at any cost we are going to complete directors and KMP. Right. Thank you.